everyone, it is Adelola Sherilyn Dow, your divorce lawyer, here to help you turn fear into power when happily ever after fades away. Today I want to talk to you about the concept of counsel fees in matrimonial or divorce actions. Yesterday I had a telephone conversation with an attorney who is an adversary on a case but doesn't really practice matrimonial law, and she, in response to my request for counsel fees, gave me an interpretation of the law that was completely incorrect. And I told her that in giving that interpretation, she would be doing her future clients, who are the non-moneyed spouse, a disservice, and also improperly advising her moneyed spouse client. Now, here's the way counsel fees are assessed. Both in New York and New Jersey, the court has the ability to assess counsel fees against one party in an action. Typically, it's done against the moneyed spouse. And when I say moneyed spouse, I mean the person who makes the most money. All right. This is usually an exercise that is not done taking into account the non-moneyed spouse, or the person who makes the least amount of money's access to assets, etc. And the reason why is that the case law of both states indicates that the court can't force someone to use their assets in order to fund litigation in a divorce. All right. So generally, the presumption in New York is that the moneyed spouse pays all of the counsel fees. However, I will tell you that both in New York and New Jersey, that doesn't usually happen. Usually judges like to have even the non-moneyed spouse have what we call quote unquote skin in the game, so that that person doesn't prolong the litigation because they essentially have nothing to financially lose in terms of paying their lawyers. And so generally what I see is that the more money the non-moneyed spouse makes, the more likely it is that counsel fees will be done on a pro rata basis. So let's say that you make 70% of the income, you may have to pay 70% of your spouse's counsel fees on what we call a pendente lite, or temporary basis. It's often best to try to negotiate these things, especially if you are the moneyed spouse. You want to try to negotiate this and not have it fall to the hands of a judge, because you can potentially, number one, save money by coming ahead of your spouse's attempt to file motion practice. Okay, because motions only cost money, and so if you try to negotiate that, you may be in a better position to save yourself some money on counsel fees, not only for yourself but also with respect to whatever you'd have to pay for your soon-to-be ex-spouse. All right, so I just wanted to give you that quick little tip and an update on the law. Thank you so much for watching. If you like this video, please click like. If you think somebody would need it or that it would be useful for any of your friends, click share along. Thanks for watching.